One more lawyer on our side before the lawyers of A3 would also cross-examine him. To our surprise, the prosecution rose to ask the court to be allowed to withdraw the application. We couldn't oppose the withdrawal because our position from the beginning is that the application had no merit and it was going against the right to fair trial. You cannot be subjected to trial with a blindfold where you do not know who is your accuser, where the evidence is coming from. So whereas we welcome the withdrawal, we also note that the court's time has been wasted, and we said it to the court because 2 days of cross-examination, the prosecution must have known that their case was very weak, and that is why they have withdrawn to avoid dismissal. We asked the court to allow withdrawal with prejudice, meaning they cannot bring such an application again. But the court has given them a free hand. We also asked for costs. The court also has not allowed the costs. And the court now has ordered them to give full disclosure by tomorrow and ordered us to come back to court on the 1st, which is Monday. We are not happy with that because we will not have had time to sit down with our clients to know what is contained in the full disclosure, to get instructions, and for us also to be able to advise our clients. When we express displeasure in court, especially of the judge refusing to give us a date for our bail application, yet he is giving prosecution dates on every application they bring, including the one that he has just finalized. He has requested us to go and canvass that in chambers with the prosecution. So from here we will go to chambers. But we and our clients feel that the judge has not treated our applications fairly. He's giving the prosecution priority. The scales of justice must always balance between the defense and the prosecution. And a court of law should never be seen to be leaning on one side. We have at least pointed that out to the court.
No question.
Fu Said, an observer, he has been here before, all the way from Senegal. He's a Comorian practicing law in both Paris and Senegal. And he has come here to see how things are going. So we are glad that the outside world is also, through the lens of the media and the lens of observers, able to follow what is happening. And don't forget, today is 558 days since Besigye and Lutale were abducted from Kenya.
Given us statements of 5 witnesses, who among others include Abe Kandiho, who was in charge of CMI, Birungi, who also once was chief of CMI, and also Lieutenant Kana Twine, who is in charge of special investigations, and the current head of CMI, Major General Otto. There is also a businessman called Barasa. Those are the 5 statements they have given us. In total, they have confirmed that now they have given us all the statements, the witness statements they intended to rely on. So, in a nutshell, they have concluded the disclosure of the evidence they intended to rely on as required under the law. Unfortunately, again, you can see there was a choreography which was made probably by the state in collusion with some other actors, and it featured prominently in the proceedings today. You can all attest to the fact that the judge's mood has totally changed. Initially, he was ballistic, he was belligerent. Along the way, he somehow toned it down, and then he was accommodative to us. But now he has engaged a new gear. He's actually going back to where he started from, to the extent that he has made an order which for intents and purposes one would consider to be irrational, that hearing should commence within 7 days from today. We are not done with the preliminary hearing. We are not done with the process of appointing assessors. We have just received the final batch of the documents the state intends to rely on. We have not even had the opportunity to interact with the Colonel Dr. Besigye and Obedi Lutale to interview them on the evidence that has been given to us. There are voluminous records the state has given to us, including flash discs of visual, audio, all these interactions they intend to bring to court, all this kind of evidence. We have not had the opportunity of discussing it with the Dr. Besigye and Obedi Lutale, but the judge insists that it must be done from 8th and 11th, that we should be on the road proceeding with the hearing by 11th of this month. We try to indicate to him that, you know, this month has got 2 holidays. The period he's talking about has got 2 holidays. 3rd June and also 9th June, which is Heroes Day. He insisted and said, you know, his order is more or less cast in stone. He was not ready to shift an inch, to the extent that he had to direct that if we can be permitted to access the prisons and access the suspects there, the accused persons, on holidays, even on weekends, even at night. You can imagine, and you ask, what has changed all of a sudden? The state has always been, they have always been taking their time in prosecuting the matter, filing one application after another.
Withdrawal of the application, but we are urging that the court allows the withdrawal with prejudice. Mr. Karua Mpanga, I've just asked the court, said we have no objection to the withdrawal, but they deal with prejudice, that you cannot bring the same application again. Especially so because the prosecution has waited for the court to utilize 2 days of cross-examination of the witness, yet nothing new has happened. They could have evaluated the options open long before they brought the application. We therefore believe that the application has been made at this stage because the prosecution has realized through the cross-examination that their application was ill-advised and has no grounds to stand on. We're therefore asking, my Lord, that the court takes the unusual step, utilizing its inherent powers to allow the withdrawal on a prejudice basis, but to also take the unusual step to award the defense costs of the 2 days this application was prosecuted, which cost should include my airfare from Kenya and back for 2 days. Because it is unnecessary that for any of us to bring an application where you have other alternatives. We also do seek the courts to require the prosecution to obey its earlier order on full disclosure and to give a timeline so that we may return to court for scheduling and for the court to be satisfied that the full disclosure has been made and therefore the case is now ready to proceed. Before I proceed to my colleagues who may want to make additional comments, I want to draw the court's attention that we do have a bail application. I don't know whether the court wants me to do this after that, this application. We do have a bail application, criminal application number 0213 of 2026, which has been allocated to you, my lord, and we will be seeking for date at the end of this, noting that our clients have been in custody, A1 and the A2 have been in custody for a whopping 558 days as of today. I don't know whether Apollo has something.
My lord, prosecution cannot be condemned to costs in this matter because it had no control over the period when cross-examination took place. And in any case, my lord, the record has it, my lord. I made it categorically clear on the 23rd day of April 2026, before Chomohedo Joseph could be cross-examined, that the matter, that application be expeditiously had on that same date. And I had even prayed to ensure that each advocate is given specific time within which to cross-examine. And my lord, it was the discretion of this court that counsel for the respondents or the accused persons take their time in cross-examination. And that explains why you have taken all these days, my lord. So we pray that this court finds that application, my lord, redundant, given the circumstances. It is our prayer, again, that, my lord, this application, as court, since they have not objected to it, it is withdrawn unconditionally. There shouldn't be any conditions attached to it, because our focus as prosecution is to have an expeditious trial of the main case, which we think should be the focus of defense. We so pray.
My colleagues who may want to make additional comments, I want to draw the court's attention that we do have a bail application. I don't know whether the court wants me to do this after that, this application. We do have a bail application, criminal application number 0213 of 2026, which has been allocated to you, my lord, and we will be seeking for date at the end of this, noting that our clients have been in custody, A1 and the A2 have been in custody for a whopping 558 days as of today. You need to confirm, one, that the disclosures have been made, and upon the disclosures being made,
I said I have made the report, it's a must. I have made the audit is a report.
Is in the next step is shaping of the case, a date for that to happen? In which case, after the disclosures, we will have assessed the time we need for preparation. In the absence of disclosures, we will not be able to know.
As a prosecution, we are praying for a hearing date in this matter.
Confirm that you make full disclosure and then
we are going to make full disclosure by tomorrow. And our prayer is to have a hearing date. And on that date, my lord, we shall be bringing our PW 1. Our prosecution witness number 1.
For the prosecution to state that is the prosecution therefore assumed.
I've seen it.
Is the prosecution assuming that the accused persons have no right to prepare their defense?
What I'm asking you now.
No,
For him, he said that he confirms that he was followed the body report.
Yeah.
And he's applying for the hearing date. So,
Okay, then I'll let my colleague, Mpanga, respond to that. The things we want the court to know is that the information on assessors is insufficient.
what is this?
We need, if it is one has a degree where they studied, we need a short time.
What is missing?
If you look at that,
Let us start with one with the SR.
they are all the same.
What is missing?
It is indicated that, like in this first one, it indicated was a degree in accounting and finance.
My question is what is missing that we can provide?
The university she went to, you know, the way
Under
one
which
gives-
law requires the assessor to have a university degree?
How are we able to be? It's not, I am not saying that the qualification, there is a law requirement. It is the information given.
This is what
If
I'm
you
saying.
say
I
you are
wanted them
O-level,
to see the information.
if you say you are O-level, we expect you to say, and I went to this school, then a background check can be done. We expect to know where they come from.
My question is,